5 seconds to go. Start. It can thus clearly be seen that though it was specifically contended on behalf of the appellant herein that the writ petition was not maintainable on account of availability of alternative remedy, the High Court has interfered with the writ petition only on the ground that the matter was pending for some time before it, and if the petition was not entertained, the borrower would be left remediless. We, however, find that the High Court has failed to take into consideration the conduct of the borrower. It is further to be noted that though the High Court had been specifically informed that on account of the subsequent developments, that is, confirmation of sale and registration thereof, the position had reached an irreversible stage, the High Court has failed to take into consideration those aspects of the matter. This court, in the case of Walji Khimji and Company versus official liquidator of Hindustan Nitro Product Gujarat Limited and others, has observed thus. In the first case mentioned above, that is, where the auction is not subject to confirmation by any authority, the auction is complete on the fall of the hammer and certain rights accrue in favor of the auction purchaser. However, where the auction is subject to subsequent confirmation by some authority under a statute or terms of the auction is not complete and no rights accrue until the sale is confirmed by the said authority. Once, however, the sale is confirmed by that authority, certain rights accrue in favor of the auction purchaser, and these rights cannot be extinguished except in exceptional cases such as fraud. In the present case, the auction, having been confirmed on 30th July 2003 by the court, it cannot be set aside unless some fraud or collusion has been proved. We are satisfied that no fraud or collusion has been established by anyone in this case. In our view, the High Court ought to have taken into consideration that the confirmed auction sale could have been interfered with only when there was a fraud or collusion. The present case was not a case of fraud or collusion. The effect of the order of the High Court would be again reopening the issues which have achieved finality. It is further to be noted that this court, in the case of Dwarika Prasad versus State of Uttar Pradesh and others, has clearly held that the right of redemption stands extinguished on the execution of the registered sale deed. In the present case, the sale was confirmed on 2nd November 2020 and registered on 11th November 2020. Insofar as the contention of the borrower and its reliance on the judgment of this court in the case of Mohammad Nuh Supra is concerned, no doubt that non-exercise of jurisdiction under Article 226 of the Constitution on the ground of availability of an alternative remedy is a rule of self-restraint. There cannot be any doubt with that proposition. In this respect, it will be relevant to refer to the following observations of this court in the case of Commissioner of Income Tax and others versus Chabil Das Agarwal. Stop.